And so this particular case is going over. And so because again, I said the litigation campus is not yet live and ready, I do have a lot of material here. I have information on how to handle lawsuits with credit reporting agencies, how to deal with agreement research, improper service. I have templates on templates on templates on what type of letters to use. And so the resources are here. I just want to make sure, guys, I'm handing it over to you ready, because it's not like the credit repair campus where I could just pepper on information later on as we go. Gotta give it to you guys when it's 100% good to go. And it's not going to be perfect, but it's giving you guys the opportunity to execute this without making mistakes, because I don't want it to cost you time. And so ideally, what would happen in these situations if, let's say, for example, we didn't submit a motion correctly, it would just delay the process. It would delay the time. It would cause you to do more work, more research. And so I want to make sure that I'm walking you guys through this specifically so you understand the right way to do it, so that you don't waste time on the back end. And now what we're going to cover today is what to do when you're sued by a debt collector, right? And so what you'll see here is I have a very step-by-step process on what you should do if you're sued by a debt collector, right? Now, what I'm covering is a very summarized format of this. But as I go and I start breaking things down, I'm going to start explaining to you why you're looking for this information and why it's important that you go about this process, because there's a lot of things that these debt collectors do that have led to them being banned, right? And so for those of you who may not know, you have the FTC ban list for collectors. Some of you may not have ever seen this list, but yeah, there's an official ban list for debt collectors. And so because a lot of these debt collectors are involved in deceptive practices and they're breaking the law, they end up getting banned, right, by the Fair Trade Commission. And so there's this full-blown list of them along with their cases and their order, right? And you can see here, all of these companies have been literally banned, right? And you'll notice some of them are pretty, they try to formulate their name similar to like an attorney firm, right? And so this is why I tell you, you have to be very mindful of the language they use and the names they use in their businesses, because a lot of them are getting banned left and right. And two, if you're looking at a debt collector attempting to collect from you, you can refer to this list just to confirm they're not banned. Because if they are, they're actually trying to collect on you illegally, and you can use this against them. You can pull their case, send them a letter, and actually sue them, right? And so I wanted to share that with you because that's one really important topic you guys have to keep in mind, because as we go into step one, I'm going to be covering a very specific thing, right? Now, there's a lot of scammers that are out there, guys, when it comes to debt collectors, right? And it's related to the ban list because a lot of them could create these case numbers, right? And so the reason why it's important for you to read the letter that you received is because the language in it is going to specify what type of lawsuit it is. And second, you want to always make sure that the case number and the court name on the document is legitimate. And so what would you do in this case? You call the courthouse directly. So you call the courthouse and you would refer to the case number, which would be right here. So I blocked this out for privacy reasons, but this case number right here is what you would call the state of Michigan in the 38th Judicial District Court's phone number and inquire about it. So what you're going to call them and say, hey, I just want to confirm this court case number and the date of this specific complaint, right? And so then you get confirmation. But if you don't get confirmation or they say it doesn't exist, then you received a scam, right? It's a fraudulent complaint. It doesn't even exist. Because if it's not in the court system, it's not a legitimate case. And so you've been bamboozled, right? And so you want to make sure that you verify the validity of it. And you simply start by calling them. That's step one, right? And that's the first step you want to take to make sure this is legit, that is actually worth your time, right? So once you've confirmed the case number, right, and you made sure that everything's good to go, correct? You're going to move over to, was the service done properly? Now, for those of you who may not know what service is, right? Service is how you get served. right? How did they serve you? Did they serve you via a sheriff? Do they serve you via electronic mail, email? Do they serve you via hand? Do they serve you via regular mail, right? How do they service you? And so the first step we're going to take here is we're going to determine whether we were serviced, right? And so like, let's pretend that we're reviewing this particular case now, right? And we've called the courthouse and they said, yeah, the court has that on file. It's legitimate. We're moving on to step 2 now, right? Because we wouldn't be moving on to step 2 if it's not legit. Like there's no need to do any of the rest of these steps because we've just squashed it on step 1. But because of where we're at right now, we're going to step 2 because we just confirmed that it is a legitimate court case, right? And so there's multiple ways to determine whether you were served improperly, right? One, it could have been delivered to the wrong person, neighbor, family, etc. It was sent without a signature, served with an old address, incorrect address, delivered by someone not legally allowed to, right? Not a process server or a sheriff. And so they would have to confirm who that person was. Then you also have, the papers were served too late. So there's a window of when they should have been served by, right? No required notice beforehand. You were served by email or electronically without your consent and not following local court rules. And so ideally, the local court rules encompass a lot of these. And so what we're determining now is we want to confirm, okay, well, what are the court rules for this particular case? And so we're dealing with the state of Michigan Judicial Court, okay? And so I'm just going to go to Judicial Court, and you need the county. So you want this specific county in Michigan. Service procedures for lawsuits. What are the requirements? So we're confirming what are the requirements for this very specific county. So because you're in Michigan, it doesn't mean that the entire state of Michigan is served the same way. It's the very specific county. The Michigan court has specific rules, and then the county has its own rules. So you want to determine specifically what those rules are. And so it says here that Michigan service of process requirement. So the governing rules of timing. And so it says here that Michigan service rules are found that in Michigan court rule, specifically service made within 91 days of filing the complaint, or the case may be dismissed without prejudice, unless you obtain more time or show diligent effort. Proof of service must be filed before the summons expires, right? And this is essential to establish jurisdiction and avoid dismissal. And so this is something that applies to the person that's serving, right? This applies to the people who are serving this, which, let's say, for example, is a sheriff or the individual that's assigned to serve this particular document. So the method of service, right? Person service is individual. So deliver a copy of the summons and complaint directly to the defendant. Service by mail, send summons and complaint via registered or certified mail, return receipt requested with delivery restricted to the addressee. So service is effective when the defendant signed the receipt. Attach that signed receipt, green postcard to your proof of service. Substitute service on individual. So available to the defendant is unavailable, requires serving summons and complaints to an agent, employee, or Michigan or representative in Michigan, right? Plus sending by registered mail to defendant's last known address. And so right now we've established two things. Person service on individuals. So to deliver a copy of the summons and complaint directly to the defendant. We got to determine who though, who's delivering it. Available when defendant is unavailable requires, so these are substitutes, and then special circumstances. So the statements such as minors, assumed names, guardians, and business entities have tailored rules. For example, minors serve someone with custody. Guardians, conservators serve them, businesses. All right, this is for completely different situations. Proof of service. So required to show the court that service actually was occurred properly, right? And can be established. So the defendant's signed green return receipt for service by mail, sworn affidavit from a person who served the documents, or the process server's affidavit confirming personal delivery. And so these are the things we're going to have to determine. So remember this, guys. This is for Michigan. But we're going to get to the specific county and see if anything changes for the county. But the overall requirements for Michigan are here. But as we get to the county, we're going to see if anything's very detailed or specific. Legal and jurisdiction implications. Courts require proper service to gain personal jurisdiction over the defendant. Improper service may result in what, guys? A dismissal. And so why are we doing this next? We're doing this next because step 2 is determine if it was improperly served. So you guys don't have to go through all the headache, right? You guys are saving yourself time and energy here. You're determining if it's legit for one, and then you're going to determine was it delivered correctly? Because if it wasn't, you guys can get it dismissed just off of these two things, okay? And so that's why there's a very particular process to follow whenever you guys run into this issue. Now, applying this to the 38th District Court, right, follows these statewide Michigan service rules. So you begin your lawsuit by filing the summons complaint, paying applicable fees, and serving the defendant as described. So the court's local policies don't deviate from this particular law, which requires so above methods and timelines apply. And so it looks like what the district is, right, for this particular case, applies to the entire Michigan rule, because this is what is supportive of the timelines and the methods that are required in which someone should serve. And so that's actually not changing, and that's what this is confirming. And so the time frame is 91 days to serve and file proof of service, deliver in person, right? If service by mail, certified and registered, right? Attest with return receipt. And so the next question will be determined, because based on my discussion with the student in here, you know, she mentioned that it was delivered in person, right? And so we want to determine, how can we determine it was the proper person? And so I'm going to ask ChatGPT, right? Mail was delivered in person. How do I know I was served by the correct individual, right? And so I have a feeling it's by requesting that affidavit, okay? Who can legally serve papers in Michigan, right? A professional process server, right? Commonly hired for lawsuits must provide a sworn affidavit of service. And so here are 3 angles we could take. So because we know it wasn't a sheriff, deputy, or court officer, often used for service, which is very reliable, the professional process server, or any legally competent adult 18 plus, allowed if they are not a party to the case. And so that's interesting. That's pretty interesting. So this saying here that in the state of Michigan, it could be any competent adult, which to me, it sounds like it's a little off to me. What makes service proper, right? To be considered valid, a person's service must follow these rules, right? The summons and the complaint must be personally handed to you or left at your residence to whom was 18 or older, right? And after serving you, the server must sign a proof of service affidavit, which is filed with the court. So how to check if the service was proper? And so we're going to look up the court record. So we got to go to this website. And we won't actually be able to pull it up because it's going to pull up your private information, Selena. So we're going to actually just, I'm going to walk you through this, but this is what you're going to have to do. You're going to have to go on the website and the search tool, or you can call the clerk and then ask for a copy of the proof of service. So right now, if I was you, because we've determined that in order for this to be legitimately delivered to you as of right now, and for it to be proper service, they need to be able to provide you with the proof of service that includes the affidavit, right? And the affidavit is required for the state of Michigan, right? And so that form is considered form MC 302, which is filed with court. They must sign this. And so if that wasn't signed and they don't have that, this can get it dismissed for you, right? How do you get it dismissed? By determining they don't have this done. And so that's one angle. So let's say they do have it signed. We'll move on to step 3 to show you what to do next. But in the meantime, the next step that we're taking is we've called the court. We determined, okay, this is legit. Now we're determining if we can get this dismissed based off of improper service. How do we determine it's improper service? Confirm that the proof of service also included an affidavit and that the proof of service affidavit is on file with the court. And we can do that by calling them or just going to their website. And so now you need to determine the name of the person who served you and then confirm the proof of service, right? Because it wasn't done via mail. If it was done via mail, you would need the green return receipt and certified mail documents. But because it was done in person, you want to make sure that we're looking for the affidavit, okay? And so once you know their name, right? If it was a sheriff or a deputy court officer, that's valid, right? But if it was a professional server, there must be an affidavit, right? And so if it wasn't a sheriff, deputy, or court officer, right? If it was a sheriff, deputy, or court officer, it was served properly, right? Because it was handed to you by a sheriff, deputy, or court officer, right? And that's according to the Michigan rules. But if it was anyone that was an alternative, it requires that the professional process server filed an affidavit. Now, if it was a plaintiff or plaintiff's relative or anyone that is directly involved, that's invalid it's invalid. If it was a plaintiff, plaintiff's relative, or anyone directly involved, that's invalid under Michigan law, right? That's considered invalid, right? If it was anyone that's related. And so we want to make sure that we confirm it's this one, because we know that since it wasn't delivered by any of these top 3, we have only this option left. And so
surroundings and energies and all of that. Like, yo, come on, you can't do this.
all right. And so step 3, watch for signs of improper service. So the person refused to identify themselves when serving you. The person left papers with the random neighbor. No proof of service was filed in court. And so, Selena, this is what we're looking for. We're looking for no proof of service filed in court. That's what we're looking for right now. We want to confirm that because we've identified it's potentially a professional process server, we're looking for an affidavit on file. And so you want a name of the individual and you want the proof that the affidavit was served. And so we were going to determine that by following the next steps. And so what to do if there was improper service? If you suspect there was improper service, right, you would file a motion to squash the service, right? This asks the judge to declare that the service was invalid. You must explain why, right? You have to explain to them that they violated this particular rule, right? And you want to request more time to respond. So if improper service causes a delay, you can request an extension to file your answer. Do not ignore the lawsuit. And the reason why I tell you do not ignore it is because they're just automatically going to win over you, right? They're just going to win and they're just going to get a default judgment. And so because you didn't say anything, you kind of just gave up. They're going to assume otherwise because that's how the courts work. And so you want to call the number, request the very specific information from them, right? Proof of service. You want to request a proof of service on file and request a copy, right? And so by requesting this copy, you're determining whether this was done correctly. And say, let's say you don't receive this information. Now you have an opportunity to get this dismissed without having to deal with any of the headache because they did it all incorrectly. Now this is all going to get dismissed. And so once we determine all of this, guys, right, we then put together our letter to squash the service, right, and confirm that it was improper. And so we can have a letter filled out for this. And so since we're in this position, guys, where typically when you're dealing with debt collectors, these are the number one two things you always want to deal with first. You want to deal with determining whether it's legit. And then two, you want to make sure it was delivered properly, because just off of these two, you can get them dismissed. But guys, let's just say that these two were done correctly. It's valid. It was served properly according to the counties and the state's rules. Now you're going to actually follow the next step, which is step 3, where you have to respond within 30 days. And so when you respond within 30 days, you have to deny all allegations. And I'm going to walk you through what that means. Why you have to deny all allegations, right? And so I'm going to show you what those are. And so in this particular case, this is the summons. So this summons says that, there is no other pending civil action arising out of the same transaction or occurrence as the alleged complaint. And so this is what was checked off for a civil case. So what the most important part of this, guys, is going to be right here at the bottom, right? And so it says here that notice to the defendant in the name of the state of Michigan has been notified you're being sued. You have 21 days after receiving this, right? And so it tells you when it expires, right? This tells, because that's where that 91-day rule is. Are you guys seeing that 91 days? Right? It's basically 3 months. And so after receiving this summons and a copy of the complaint, to file a written answer to the court and serve a copy to the other party or take other lawful action within court, with the court, 28 days of if you were served by mail or you were served outside of Michigan. If you do not answer or take action within the allowed time, a judgment may be entered against you for the relief of the demanded in the complaint. If you require accommodations to use the court because of disability or you require a foreign language interpreter to help you fully participate in the court proceedings, please contact us immediately to make arrangements. And so it's telling you here when you have to respond. And so this was delivered on which date? When was it delivered, Selena? 8/24?
It was like last week, sometime last week.
Yeah, so we have plenty of time, right? And so we want to respond to this preferably this week, right? We want to send over a letter once we determine whether or not they have an affidavit on file. Because if they don't have an affidavit on file, Selena, we then proceed to building a letter to get all of it dismissed and squashed, right? But that's the next step. And so what you want to do first before you send this letter out and you respond to them, Selena, is you want to confirm if they have an affidavit on file, if they have that information on file. And the reason why is because this can delay your ability to respond, because you want to determine if you were served properly. That is the number one thing here. You want to determine if you were served properly. And so you're going to call them and say, hey, look, I just want to confirm based on this case number for this date, if there is an affidavit on file for the individual that issued the summons, and I would like the name of this individual. And so they're supposed to provide that for you. And if they don't have it on file, I'm sorry, hey, we don't have that on file. Selena, now you have to craft a letter to get it dismissed, and that's going to be your response. Your letter is going to include a request to squash it and also a denial of all allegations. And you have to deny the allegations, because if you don't deny it and you try to still squash it, they're still going to assume that you didn't deny it, that it's all true, because everything in the United States is based off of the law of presumption. So if you don't rebut it, it's based on presumption. So there is no other pending or resolved action arising against this out of this transaction or occurrence alleged complaint. So here comes plaintiff capital one by the attorneys of Weltman, Weinberg, and Rees company. So this is actually the company that's suing you. It's not Capital One. The plaintiff is not Capital One. It's them. And so if you guys don't pay attention to the language, because why are they involved if Capital One is the one suing you? And this is the stuff you have to pay attention to, right? And I share this with other cases where they claim to be the plaintiff when it's really not. So the plaintiff is doing business with, in this particular county in Michigan, a defendant is a resident in Michigan. The cause of action in the form of basis occurred in this county, and the venue and jurisdiction are proper in this district court. And so what's next, guys, is going to be the allegations. And so these are the allegations. And so, Selena, I don't know if we're missing the other ones, but there should be some other information.
I sent you.
Actually, no, we got everything. So yeah, it's everything. So
Okay.
These are the legit allegations, guys. And this is what you have to deny. So the allegations are these specifically. It says here, the defendant opened a revolving credit account used by the plaintiff, currently identified by this account number. Through his or her use of the credit card, defendant agreed to pay the plaintiff all transactions, interest, fees assessed on the account. Plaintiff provided monthly statements and defendants reflect to the defendant, reflecting, among other information, transactions and accounts since preceding billing period and the total amount due on the account and the minimum monthly payment due. Despite demand of plaintiff, defendant has failed to pay the amount due and owing to plaintiff on the account pursuant to the terms in a credit card agreement. Remember, guys, they're always going to pursue the credit card agreement. So I tell you guys, always read your agreement. I'm always going to preach that to you guys, because if they're going to ever sue you, it's always based on your agreement. There is now due and owing to plaintiff the principal amount of this amount. Plaintiff does not seek any award of attorney fees, contractual, or statutory interest after the date of charge-off, including any postponed judgment interest, and expressly disclaims any right it may have to the same, right? So right now, what it's saying here, that basically Capital One does not seek any award of any of this, right? Because guess who's actually looking to collect from you? The collection company. So if Capital One isn't seeking any award of attorney fees, contractual, or statutory interest after the date of the charge-off, including any post-judgment interest, and expressly disclaims any rights it may have to the same, pay attention to that language, guys. Capital One's not involved in this, right?
So that means it's really nothing.
What this means is now you have a collection agency basically claiming to be Capital One, which they are not. And they're stating here that Capital One does not look to seek for any award or any attorney fees. So who's really seeking this? It's that company. So how is that company now representing Capital One? You never signed an agreement with this company, right? Known as Weltman, Weinberg, and Rees, right? You didn't sign an agreement with them. You signed an agreement with Capital One National Association. And so they're claiming here in these exact words that Capital One is not seeking any attorney fees. Capital One is not seeking any contractual or statutory interest after the date of the charge-off. Basically, Capital One's washed their hands with this. Capital One's done, but why is Capital One involved in the lawsuit? They're done. That's what it says here. And so this is why you have to deny all allegations. Because now you have to challenge the fact that you don't have an agreement with Weltman and Weinberg. That they need to provide you with the specific agreement. Right? So that's where validation of debt comes in. Right? And so typically what happens here, guys, the reason why this lawsuit took place is because it's very likely, this is usually how it happens. It's very likely that we're on this date. So probably possibly a month or two before this, Selena you must have received a letter in the mail of them attempting to collect a debt.
Yes, I did.
And then once you ignore that, what they do is they file a lawsuit, because what you should do when you receive that is submit a validation of debt. Because if they ignore the validation of debt, you can use that against them, because what you could do is file a motion to dismiss based on failure to validate the debt. But we still have a case, because we can still leverage motions and we can still get cases dismissed based off of improper service, based on legitimacy, and we can file motions later. But the goal right now is to identify what the flaws are. Now, the same way we're looking for these flaws, guys, they're doing the same to you. This is why I tell you, when it comes to the litigation campus, I got to make sure you guys understand everything and make and execute it correctly, because those very same flaws could be used against you. Right? Think about that. If, for example, I'm sharing with you that if it was supposed to be sent to you by a sheriff and the sheriff didn't do it, then you can use that to get a case dismissed. Now, think about all that time and effort that the company did. They paid the fees, they filed a court case, they created a complaint, and then now it's dismissed because the wrong person serviced them. Think about that, guys. Same thing can happen to you. And that's why I'm trying to teach you guys that it's very sensitive. It's a very particular way of handling these type of situations. It's different from just credit repair. And so ideally, because we're going to deny all allegations, right? We deny all the claims that you didn't do business with the collector, right? Because remember, the collector is the one who's attempting to collect. They don't have the real proof. And basically what they do is they often buy these documents, they buy this debt, right? They buy it's a file. So they're not actually getting the real agreement. It's a file, it's a debt file. And they get a lump sum of files, and then they start issuing summons and letters to people for debt collector. And that's how they end up getting people to pay. And these debt collectors make a ton of money off of nothing, because some people end up paying, right? And so I'm teaching you guys how to challenge that, because they're not legitimate. Hence why there's a ban list, okay? And so I list this disclosure here to get legal defense if you need it, but I'm teaching you guys how to handle it on your own, because you don't need legal defense. Because what's going to happen is, based on my experiences, they're getting paid to convince you to settle. So they're going to get a little bit of a cut of what's going on, right? And so they're going to convince you to, hey, we could settle with them and do this, and, we can, we'll take care of it from there. And then this will be all good. That's their angle, right? So this is the reason why I'm educating you guys and I'm giving you guys the tools, is because I've seen this happen in real time. And so I'm going to give you guys, real life examples of how to handle this. And it's different in every state, guys. It's different in any county. And so the whole idea here is to give you the blueprint. This is the blueprint on how to step-by-step execute process of elimination, because you're going to be identifying the flaws in your particular situation, because not everyone's summon is going to be the same. Not everyone's county is the same. And so by understanding the format and understanding the blueprint, you guys now have the ability to handle these cases on your own and understand how to navigate. Second, you guys have this community, right? And that's the whole power of having a community. You drop it in the Q&A, say, hey, this is what's going on. I need to know how I can handle this. This is what these calls are for. We do these 3 times a week.
Yes.
And so I'm always open to doing this stuff, but I always want to make sure you guys are also reading your agreements and that you're understanding what is going on. Okay. And so step 6 is to file it with your court, right? Once you've determined everything, right? You determine that, everything was properly served and now you need to respond to them. You want to file it with the court. You need to pay any applicable fees. And then you also need to submit your response with them within the required deadline. And then keep proof of the fact that you did that. And then always keep copies of everything, right? And then once you've sent your response, they're going to respond to you with the official court date, right? And the official court date is usually the hearing. And so you guys are probably wondering, all right, what happens in the hearing? Well, when you show up, you just agree or disagree. Don't do a lot of talking. The judge will ask you, do you agree that you owe this debt? Your Honor, I do not agree. I dispute the validity and the ownership of the alleged account. That's it. And you call it a day. You don't talk anymore. That's it. You disagree to everything, guys. And the reason why is because once you disagree, you've now, right, a creditor who no longer owes the debt due to securitization or transfer to a trust does not have the standing under this rule, right? The federal rules of civil procedure. And they must prove assignment, and must prove chain of title and legal authority to collect. And if they can't show this, the case is dismissed, guys. But when you go into court, you can't say things that are going to set you up. You keep it short and simple. Your Honor, I do not agree, and I dispute the validity of this. It's simple. Don't go ranting on about whatever you dealt with and that, it's illegal. You don't do any of that. You just keep it short and simple because they'll use all of that language against you. Okay? And so the first hearing, guys, is simple. You're not going there and they're not going to come up with any verdict. You're simply showing up to agree or disagree. It's the second hearing where what happens is after the first court hearing, that's where your motions come in. That's where we file a motion to dismiss based on improper service, based on failing to validate the debt, failing to provide proof of ownership, failing to do whatever, right? That's where you can file your motions. You want to demand proof from them. Because once you've denied everything, that's where your motions come in. You file these motions for lack of standing for literally everything that we've built up until this point. And so far, what we're trying to do is potentially not even go for the first hearing, because if it was improperly served, you can get it dismissed based off of that. But if, say, it was properly served and you did receive it, you still have to go to the hearing. Show up to the hearing. You say, I disagree. I dispute the validity of this. And then from there, we can move forward with motions. We start creating letters to file motions for dismissals. And so that's pretty much that. And so what I want to do is I'm going to open up for questions. So I have Selena drop the question in there. Say, okay, understand, confirm. Proof of service is an affidavit. Absolutely. This is my exact situation with Capital One, but in Maryland. Yep, exactly. So you're in the same situation. And so these are the exact steps you want to follow to determine if you were properly served, because you can actually get this stuff dismissed just off of those grounds, because you're not going to court to argue that you owe the debt. You're challenging the fact that the debt collector has no valid ground to collect on you. Because why isn't it Capital One coming against you? It should be Capital One. That was in the original agreement. So where can I find a credit card agreement for Capital One if I don't have a copy? It's a good question. You can go to their website, right? Or you can go to the CFPB. So Capital One agreements. So their websites, actually, Capital One is actually one of the few that gives their full list of agreements on their website. And so based on the card that you have, let's say you have a Kohl's Rewards card, just click on it and it will pull up the exact agreement for you. The second alternative that you have to finding this, you go to the CFPB and type in agreement database. CFPB also has a credit card agreement database, so you would search Capital One, right? Capital One National Association Bank. And so they have their database here as well, right? And so if you have a credit card for Capital One related to, let's say, for example, just their credit card agreement for a Visa signature, then that's what it is, right? Or a consumer card. Here's the PDF, or a secured card, right? If you had a secured card, this is the agreement, and so forth. And so that's where to find the agreement. So how do you deny any allegations in a declaration? You verbally state. And so what you want to do is to deny all allegations is a really good question. I missed the hearing, although I filed a motion to postpone. Now it's a trial. Okay. And so typically, yeah, you want to do everything timely as possible. And so what I'm going to share with you is when it comes to denying all allegations, what you want to do is review the allegations. And so you want to be specific about the allegations you deny. And so it's this page here. And so it's going to be different for every case, guys. And so you want to deny the allegations from, let's say, 5 all the way through 10, right? And you want to be specific. You want to list all allegations. You want to deny all of them. I'm going to explain to you why. Because remember, the individuals that are claiming this against you is the collection company. All right? Is the collection company. This isn't Capital One. Right? And it's being clear here as to specifically what's going on, and that even the plaintiff does not seek any award. Remember, the plaintiff isn't really who's coming after you. It's the debt collector. So how is it that the plaintiff is not seeking any award of attorney fees, contractual or statutory interest after the date of charge off, and then expressly disclaims any right it may have to the same, but yet you're claiming that this is owed? Which one is it? You have to deny all allegations. So list all the allegations and deny each of them. So I would state, I deny this out. I deny this, right? I deny this and I deny this. You want to list all of the ones you deny and specifically deny them. So you deny all allegations. And so you don't need to craft anything specific. You simply go based off what they are claiming against you. That's their allegations. That's what they're taking to court and they're saying. So they provided a notary document stating one of Capital One's employees has reviewed the books and records. Okay, but my question to you is, did you read the actual lawsuit? Like when you read the lawsuit, is there a collection company on there? Because if there is a collection company on there, it has nothing to do with Capital One. They can notarize all the documents they want, but right now, as I just showed you, they're claiming that Capital One is a plaintiff, but it's not. Capital One isn't showing up to court. It's the collector. It's a debt collecting company. Right? And this is why when I'm teaching you guys this stuff, it helps to know like the sequence of this all, right? So what happens is the moment you receive a debt collecting letter, you have to send a validation of debt within 30 days. They're giving you 30 days to respond because by law, they have 30 days to respond to your response. And if they fail to validate that debt, then they have no legal grounds to stand on. And they have to seize all collection activities, which means they have to seize the attempt to collect. Collection is a form of reporting on your credit report. So they can't report anything on your credit report and they can't harass you until they validate the debt. So basically it halts everything until they validate the debt. And so that's why by responding to them, you're essentially helping yourself. But if you ignore them, they keep harassing you because you didn't cease and desist. they will continue to file a lawsuit because it's all based on presumption. And if you keep ignoring them, it will lead to a judgment, meaning it's a default win against you, right? And so they're going through this entire process knowing that most people who ignore it just end up in a default judgment. And like I was sharing before, it's like, it's not the end of the world if you forget. I've done it in the past. I had a loan. I got like a $10,000 loan in the past, and I was young and I spent it and did all this kind of stuff, and ended up going through judgment, and I ignored it. I just didn't care. And then I checked the statute of limitation. It expired. Nothing ever happened. And so there's a lot of cases where that happens. Worst case scenario, they get the judgment and then they attempt wage garnishment, right? They attempt wage garnishment. And this happens in some cases where it can happen later down the road. They won't actually go after it right away. Where, say, for example, I'm going to share with you right now, statute of limitations. So the statute of limitations in each state. All right, and just to give you an example, right? Just so that you guys can see. All right, so open-ended debt or written contracts, promissory notes. So you can see the amount of years they have to collect on you. Right. And so let's say, where we're looking at Michigan. So Michigan is 6 years. All right. Where Missouri is 10. Right. So Missouri's got plenty of time to collect on you. Where if you look at, let's say, for example, let's look for a short one here. Like for me, my debt was out of New Hampshire, so it was 3 years. So that's why I looked at it as statute of limitation. I looked at it 7 years later, it was done. And so there was no way they could come back and collect on it because the statute of limitation to collect on a specific type of open-ended written promissory or oral contract has expired. And so even if you end up with a default judgment, if they didn't actually collect on you within the statute of limitations, and it's expired, it's done. They can't come after you for that. So that's what those judgments are for. Those judgments are put in place so that they can, at whatever reason, at any time, if they want to start pursuing employees and say, hey, this person owes this debt, we want to wage garnish, that can also be reversed, but that's usually what happens, right? That's what their end goal is, but it doesn't always happen. And so I'm giving you guys real life scenarios of the type of situations that occur when dealing with these debt collectors. It just really comes down to who they are and what they're willing to pursue. And that's just to give you an idea of how they do it.
So I have another question, a follow-up question to that.
Yeah.
I didn't take notice until someone dropped the notice on the summon at my door. And when I saw the date for the summon, I did send them a series of letters, one being a debt validation letter. They completely ignored it. So I don't know if they ignored it because it was the summon. They had already filed paperwork to go to court. But every subsequent letters I've sent them since, they've ignored it. So, and they changed the court date a couple of times. One, they changed it as I was heading out of the country. I did send them an email. Sorry, I dropped off a letter at the court letting them know when I got the change of date that I was going to be out of the country. It was short notice. And I guess they denied that. Now they're moving to trial. Does it make any difference at this point, since they're already going to trial, that I file a notice to dismiss based on the fact that they ignored my request for debt validation?
Yeah, so what you would do is, did you send it via certified mail?
Yes, I sent it certified mail to all three partners of the law firm.
And have you already denied all allegations?
No, I don't think I denied anything.
Yeah, so yeah, you have to deny the allegations. And so it really just comes down to the timeliness. And so I think in this situation, I've never really ran into this situation where they've moved it and then accelerated to trial. But remember, the trial is typically to get you to do a settlement, but you can file a motion to dismiss based on anything else you find prior to that. So you can reverse everything and start fresh and say, okay, well, let me start with the motion to dismiss based on improper service. Determine whether they did service you properly. Like, did they serve you properly? And so if they didn't,
I don't think so.
yeah, that's a very valid way to dismiss it. Because here's the thing, even if they accelerated to trial, they still had to have followed proper court procedures, so it's not a valid trial. Because you would have to be properly served in order for it to be a valid trial.
Mm-hmm.
And
Okay, because
so,
I did the search like you did with on Chat GPT,
yeah,
and it did say that I had to be it had to be hand delivered.
yeah,
I was not home. They left it at my door.
uh-huh. And so
So,
also it could be other alternatives, because remember, sometimes it says there's substitutes. So determine whether there's alternatives and where they are allowed to follow alternatives. And if they are, what are they and were those followed? And so, because some do offer alternatives, well, for example, in this particular case, um, Selena's case, she had a processor who served it versus a sheriff, where the processor is an alternative over a sheriff. So you want to determine what the rule is specifically for your county, go through all of the rules, and then determine whether there are alternatives. So were they allowed to deliver it at your door? And if they're not, that is that's your grounds for improper service. But to be able to actually prove that, right, you have
mhm,
to find the rule that they violated, right? You have to find the rule they violated. If they violated the Michigan rule, or for example, your county's rule for improper service and it wasn't hand delivered, then that's the rule that they violated, and that's what you want to dismiss it for that specific
mhm.
rule. And so that's, I think, in my opinion, would be the best route to take, because they're accelerating it to trial because they know once it gets to trial, you're going to get to court and you're going to say all the wrong things.
Mhm. And then the other thing is that they moved it from, let's say, a county court to like district court.
Mm-hmm.
Does is that anything
Well, I would still go
to
to the root.
consider?
I would still go to the root of it, right? I would look to the root of it and still begin from the beginning of the case.
Hmm.
Because in order for this to be legitimate, they have to have served you properly.
Okay. So the serving seemed to be
The serving, I'm telling you guys, like when it comes to if they fail to follow all the proper procedures,
hmm.
it's not legitimate. They got to go
Okay.
through the exact rules that the courts require. So if the court requires that a sheriff hands it and that doesn't happen, it just gets regular mail delivered to you, that's not a legitimate case.
Okay.
And so that's why, by determining the flaws in the case, you got to look at the flaws. You got to look at the rules. You got to look at what the requirements are. Did they do everything they were supposed to correctly? Because as soon as you find a flaw in it, you can throw it out using that flaw.
Okay.
That's what these lawyers do. All
Hmm.
lawyers really do is look for flaws. That's how they get cases dismissed. That's how they end up winning. They look for flaws.
Okay. So the debt validation doesn't even matter at this point because they didn't
You could use that as well. You can use it as part of your claim. I just
hmm.
I just think that because of the timing, it is going to be a little bit more difficult, because
Okay.
they do give you that window. They give you that window to respond. They give you that time. And so that's where they end up throwing things out, is they start claiming that you had X amount of time and so forth. But
Hmm.
if you can legitimately show that this isn't legit, because this all started incorrectly. It was served improperly. Like, this is not a fair case to begin with,
Okay.
right? It's not a fair case to begin with because I was improperly served. I have that right. According to your rule, I have the right to be properly served, and this was improperly served. And the judge can throw it out for that reason. But you have to call it out. You have to know which one it is.
All righty. Okay.
That
I
makes
will go
sense?
ahead and do some search. Yeah, absolutely. Absolutely. Thank you
Yeah.
so much.
And so like there's so many different angles we can go after with this stuff. It's just really understanding the nature of the cause. And so if you have trouble or you're having difficulty finding that type of information, I'd be happy to do another call on it. But ideally, like I said, that would be the angle I take for this particular situation.
Understood.
I would go after it from the very beginning and say, hey, like, I may not be able to challenge that validation. I may not be able to, or I may have delayed the response for the allegations, but this isn't a fair trial as far as I'm concerned because it was not properly delivered,
Okay.
right? And
Right.
so as we agreed here, as we see here, it says here that um
Well, that's for Michigan.
it is for Michigan,
Right.
but you know, it says here that if a plaintiff or an authorized person served you, you could challenge the service. All right. And so let's see here. When is it too late to challenge the service? It's critical if you wait too long, the court may assume that you waived your rights. So let's see here.
Oh,
So
the
so
question you
basically,
asked chat was
yeah,
when is it too late to challenge the service? Okay.
yeah. It says it's critical because if you wait too long, the court may assume you waive your rights. And so that's why I remember the presumption, the law, they presume everything. And so if you don't respond, if you don't get to them on time, they're just going to presume otherwise, even if it's not correct. Right. And so you want to make sure you respond to them. And so if it looks like here in Michigan, after you filed your answer, but before the judgment,
Mm-hmm.
if you didn't do it before the judgment, you waive your right. So right now, it doesn't look like there's a judgment against you. So determine
Mm-hmm.
whether in your county and your state, if that's the same rule, right? Determine if that it's similar. Because if it is, it'll give you that window on when you can go through and file a motion to dismiss based on improper service.
Okay.
Right?
Alrighty.
And let's
Thank you. Yeah.
say let's say you determine that they did everything correctly and they served you correctly. I would use the debt validation as your next challenge, right? Failure to validate the debt based off of my letter sent on this date, right?
Mm-hmm. All right. Because I sent 2 rounds of letters, so
Yeah,
okay.
as long as you have your certified mail delivery and the copies of the letters, that's your evidence that you requested validation of debt. Therefore, they don't have any valid reason to collect based on improper validation of debt.
Okay. All right. Thanks again. That was very helpful.
Absolutely, absolutely.
So, I guess since the litigation portal is not yet open, we wouldn't be able to see that one document that you were going over.
Not yet. I'm going to share this call so you guys will be able to still see it and go over it.
Okay, wonderful.
Yeah, I also have some other calls on there that are recorded that I went through lawsuits.
Okay, thank you.
So you'll still be able to see the material and go over those steps because those are the only steps you need to follow when it comes to challenging that stuff.
Great.
Right. And the reason it's so simplified, like I was saying to you guys again, is because it's not that complicated and it's a blueprint. You just follow the blueprint, determine what's missing, determine if it's correct. It's basically a blueprint. So for every debt collector letter you receive, you follow the blueprint. And so that was the reason I created it that way, is because it's not a one shoe fits all, it's a one system fits all that you have to now do the rest, right? Go into your county, determine the info, but you have the guidance and the structure. You need to determine if you have an opportunity to challenge it.
Mm-hmm. Okay. Thanks again.
Absolutely, absolutely. Any
Yeah, thank
other
you so much.
questions?
Thank you so much for breaking it down because now I feel a lot better about what I'm gonna do these next few days.
Yeah. And so I would get right on the call with the county, ask them specifically if they have that affidavit in file and the name of the individual that served you. If they say they
Right.
don't, that's when you'd have to proceed to creating a letter to challenge that, right? File a
So
motion to
basically,
dismiss based on improper service.
okay. So just call them tomorrow and ask for if the case number and the court name is the same. If it's different, then I'll know what to do.
If they
Write a
don't
letter.
even have that on file, it's not a legitimate case,
Yeah.
right? They don't have that on file, it's not a legitimate case. And then second, ask them if they can provide you with the name and a copy of the affidavit of the person who served you.
Okay. Okay. And then next is like how they served me. They need a proof of affidavit too
Yeah,
by the
so
individual and the name.
yeah, so you need to ask them for the individual's name and the affidavit they have on file for the individual that served you. Because if it wasn't a sheriff or officer or a county officer, then they need an affidavit based on your state's rule.
Okay, I understand. Thank you so much. So I'm gonna do that and then I'll know what to do. I'll know my next steps.
Absolutely. Any other questions, guys, before we wrap up the call?
But you have a good night. Thank you so much. I
You
really
too,
needed this.
Selena.
All right, so I'll keep in touch. All right.
Awesome, awesome.
All my questions were answered. Thank you so much. Have a great evening.
Absolutely. You guys enjoy the rest of your evening. I'll see you on tomorrow's call, and I appreciate you guys jumping on tonight. Talk to you guys
Great.
tomorrow.
Thank you.
Bye-bye.
Bye.